welcome back to the TuckerAllen Virtual Town Hall. I'm the moderator, Scott Trout, and thank you for joining again. And today's topic is of interest given a new presidential administration, and that is estate considerations and what happens under a new administration and what effect does it have on estate planning and also the current plans that you have in place. Or if you have no plans. So we're going to talk a little bit about that today as well. Keep in mind, we'd like to hear from you. You could submit your questions live in the Q&A section. We're going to answer those in the second half of our virtual town hall today. So we'd love to hear from you, try to get our panel to answer some of your questions. But in that mind, keep in mind that this isn't legal advice. No attorney-client relationship is established. We just can't do that. We'd like to have a consultation with you, get the facts, the specifics with regards to your estate and your needs and provide you the right guidance. But really, this is to give you some speaking points and take those to an attorney who practices exclusively in estate planning. And that's what our attorneys at TuckerAllen do as well. So you can give them a call, though. If you want to consult, you can go to TuckerAllen.com or you can give them a call at 866-335-3375. And on TuckerAllen, you can make your appointment right there. And you can schedule an appointment at any of the offices throughout the St. Louis metropolitan area, Illinois, and Kansas City area. So let's introduce our panel before we take a very, very brief break. Joining us again, as usual, is Teresa Yao in the Edwardsville, Illinois area. Welcome, Teresa.
Hi, Scott. Thanks for having me again. I know we mentioned this on every town hall, but I practice in both Missouri and Illinois.
Thanks for joining, Teresa. I appreciate it, as always, bringing back Kevin up in the Kansas City area. Welcome, Kevin.
Thank you so much, Scott. I am very happy to be here today.
So then rounding out the panel is Missy Manning. Welcome, Missy.
Hey, Scott. Thanks for having me on again.
Glad to have you guys. You can give us the input. And as always, I always try to throw you questions that are unexpected because I don't know necessarily the topic very well. So be prepared. And so remind everyone, submit your questions in the Q&A section. We're going to get to those in the second half. And you can ask our panel here and get answers right here and right now. So we'll be right back after this brief break.
We had a lot of conversations on what would happen if we weren't here, and I don't know. TuckerAllen was super convenient. It was so easy to go through and get the package that we needed.
The website was simple, easy to use. You could schedule a time to actually meet with somebody.
It's one set fee for a will, one set fee for a trust.
It's our wishes in place. It's everything we want for our daughter.
Welcome back. Now let's get to our topics today. And obviously, as I introed with the new administration, there is talk about major changes as it relates to trusts, wills, estate, gift, tax. I think we're going to talk a little bit about some terms that we'll have to explain, step-up basis, those things, and looking for interaction between our three attorneys as we go through it. But again, keep in mind that we'll have some questions that are submitted already, and encourage you to submit your questions now in the Q&A section. We'll get to those, but again, can't give you the great legal advice. We're going to give you some direction. I encourage you to schedule a consultation by coming in and giving us a call at 866-335-3375. So let's turn to Kevin. Obviously, the elephant in the room that I think was thrown about even during the election season was potential changes in the estate tax threshold that President Biden mentioned. And I'm going to also bring in Missy at the same time, and we'll kind of go back and forth between the two of you because it also impacts the gift tax and what people can do, and maybe their limitations and what we see perhaps coming down the road. Obviously, I'm going to ask you about changes and what you expect and maybe what general estate implications these changes may have. But let's start, Kevin, just on the forefront. When we talk about these changes in the estate tax, some have referenced it as the death tax, I've heard. What does this really mean?
Sure. So what the estate tax is I guess first I'm going to go ahead and just define what an estate is for people. So what an estate is, it's all of the money, property, personal property, just all of your assets at the time of your death. And then the estate tax would be, we have an estate tax threshold. So if the If your estate, all of that money, all of your assets, property, if they are above the estate tax threshold, then everything above that threshold you have to pay a tax on. So currently it's at 11.58 million for an individual, and then 23.16 million for a couple right now. And then there's been talk of lowering that.
So obviously, and I'm just going to throw this to you, Missy, because people watching and they're thinking, well, this doesn't apply to me. None of these old changes don't apply to me. But I think what's important to note is, yes, there's some big numbers that Kevin just threw out there. We're going to talk about what's on the horizon, but perhaps changes also affect people that aren't in that category, right? There are changes that may be coming forward, and we'll talk about the gift in a minute, but it's not just for people who have millions and millions and millions and millions of dollars, right?
Correct. So it is something to think about. You could also get the money from inheritance. If you're one of those people that have 11 point whatever million dollars right now, props to you. But if you end up inheriting, that could easily double the amount of assets that you have. So that could put you into that scenario even earlier than you might think.
So let me go back, Kevin, real quickly, as we think about this change and we talk about the 11 million and the 23 million. So the point is there's a tax above that amount. And what is that tax rate right now? Is it a flat tax?
Yep. So right now it's just a flat rate. So if you were an individual and you had money in access at the time of your death of that 11.58 million, then it would be taxed at a flat 40% rate, every dollar above that amount at that flat 40%. And then there's also been discussion too about potentially raising that tax from 40% to 45%. So that was kind of another area in there where there could be some potential changes.
So, Missy, let me go to you. And we talk about the death tax, but there's gift tax implications, perhaps changes as well. I want to put them together because my understanding is there's some, the limits right now tend to be very similar. So maybe you can talk about the gift tax because a lot of people are impacted by that part of their estate planning was to start gifting, right?
Correct. So gift tax is different than the estate tax, but they are very much intertwined. So to keep people from gifting all of their money away on their deathbed and not having to pay an estate tax, Congress enacted the gift tax, which applies to gifts made during your lifetime. Gifts in excess of the gift tax threshold are taxed at the same 40% rate. And you're supposed to report any gifts that you make to the IRS every year on your tax return that are over $15,000. That reduces the amount of money over all that you are allowed to gift or gift upon your death. So they are basically the drawing from the same pot, your estate tax and your gift tax for right now. Things might change in the future, but with this gift tax, you have to report over 15,000 and then it's the same number total. So if you gifted away all of your assets while you're alive and you exceeded that $11.7 million in 2021, then you'd have to pay taxes on any gifts you made and any gifts you made after your death.
So I assume, Missy, obviously we're talking about the importance, and it obviously sounds important, but there's a way to plan. And I mean, that's the whole point of having a planning meeting with a financial advisor, with your estate planning attorney, right? Under the current rules. So all is not lost if you do through proper planning to ensure your assets are divided among trusts, or how does that work?
Correct. So there's a couple of different ways that you can shelter your assets and protect them from the estate or gift tax limit. One of the easiest ways is to start a gifting plan during your lifetime. You and your spouse can each gift $15,000 to any person. Combined, that's total $30,000 to any one person if you have a spouse. And you can do that to anyone. So you could start gifting to your children, your grandchildren. That also excludes gifts to charitable institutions. So those don't have to worry about that $15,000 gift. There are also a couple of other ways you can shelter some of your assets by doing an irrevocable trust. An irrevocable trust takes your assets and sets them outside of your estate. Theoretically, you're not supposed to have access to them anymore, but they'll sit there until you pass away and then be distributed to your heirs however you want. But that's one way to reduce your estate to get it under the $11.7 million threshold. A very popular way of doing that is an irrevocable life insurance trust.
Mm-hmm. Where you put the life insurance in there and then the proceeds they don't touch that maximum.
Correct.
Got it. So I'd like to hear from both Kevin and Missy. We talk about what we've, the rumors throwing out about what the Biden administration wants to do. And when you talk about it, what's interesting I'd like to hear as well is, from those watching is you can make changes, which means you need to come in and get with an estate planning attorney to see what impact these changes may have on the plan that you put in place, whether it was a year ago, 5 years ago, 20 years ago, to make sure that the original plan is going to work under any potential new changes. So, Kevin, again, on the death tax, the estate tax, what are we hearing again? What are the numbers that are being floated about?
Sure. So right now, some of the numbers that I have heard mentioned have been $5 million for an individual to $3.5 million for an individual. So any assets above that, either 3.5 or $5 million for an individual, and if there were a couple, then we would double those numbers to 7 million and 10 million. So any assets above those, so cutting it by more than in half is what we have seen so far, at least what we've heard talked about.
Missy, is that what you're hearing?
I'm hearing those same numbers for estate taxes. I've heard that there's a theoretical idea of putting down gift taxes to $1 million. I'm not really sure how that would work since right now the two are intertwined, if your previous gifts would be grandfathered in or how that would work, but that's the rumor I hear is 1 million.
Some pretty drastic changes. Obviously, if you get all the way down to someone who's widowed and has 3 million and they haven't done, life insurance policy, excuse me, could put them right over the top, depending upon the value of that if they haven't properly planned for it. So obviously that's something that they'd want to consider and come in and have a conversation about, let's take a look at what you have, start planning for any changes that come forward, right?
Yes, absolutely. That would be great. If that would definitely be something that they would want to come in and at least have a discussion about, talk to a financial advisor, their CPA, get everybody on board for a discussion like that.
So Kevin, let's just generally talk about the implications of these potential changes on generally on estate planning.
Sure. So I would say if we're just going to talk about, very general things, one thing to kind of talk about is just like a need for flexibility in your estate plan, right now. So nothing has been set in stone yet. We don't know what is kind of coming down the pipe here on changes. So until that happens, we just kind of need to be able to stay flexible in estate plans. And so, a tool that if it does get lowered, this estate tax threshold gets lowered, a tool that is flexible it's called a spousal lifetime access trust. We call them SLATs all the time. So I normally don't think about it other than just the acronym. But so a SLAT is a good way where you can preserve, you can lower that estate taxable threshold, because generally the law sees a married couple whenever we're talking about things, a lot of times I see them as a single person. But whenever we're talking about estate tax, they see two people there. So with a SLAT, it allows you to put some money into an irrevocable trust, and then that trust, one of the beneficiaries will be the spouse. So then a spouse, they are able to get assets out of this trust during, their lifetime. And that's just a good way to kind of lower someone's net worth or lower that couple's net worth to try to get below the threshold. And it does allow for some flexibility as well.
Same question to you, Missy, as we talk about the gift tax. Really, what are the implications, now, and then maybe, what should they be thinking about doing in advance of these potential changes that could be drastic and really confusing, as you suggested, that may go down to 1 million and then be inconsistent with the estate tax?
So one of the big things that I would recommend is to start thinking about setting up a gifting plan if you think you're going to be close and affected by it. We're still in 2021. Who knows when this is actually going to come into effect, but if you start gifting now, you can certainly get ahead of the game. Another thing to be thinking about is charitable donations don't count towards your gift or estate tax limit. So you can start making contributions towards those if you want to reduce the overall assets in your estate, and you get a nice tax bonus for it for making those charitable contributions.
So, I think, we talk about it every week, whether it's during our Facebook Live. If you haven't tuned into our Facebook Live, it's on Fridays at 1:00 Central. You should do that. It's a very brief 15 minutes, and we're just chatting about topics like this. and then taking some questions. So one of the things I know, Kevin, you and I the last couple of weeks have talked about on Facebook Live is the TuckerAllen program that we have, the Legacy Protection Program. Maybe you can talk a little bit about that. And I mean, this just seems to me to be right in that area where someone could come in and say, okay, these changes have been made by the administration. What should I be doing here? You know, and having a consult, right? Maybe you can talk a little bit about the protection program.
Sure. So with that legacy protection program, like you're speaking of, if we have changes that occur, then you know what, come speak to us. We're not going to be charging you for that consultation whenever you're a member of the LPP program. And then we can just kind of talk about what are some potential things that maybe we want to think about down the line, or how could this possibly affect you, and what are some changes that you might like to make during your for your estate plan, where it could be something that's easy, where we could say, maybe let's start thinking about some of the things that Missy had just talked about here, where maybe let's start making some gifts, or is there a charity that you're passionate about that you would like to give some money to? So those would all be things that we, could have in that council if you're that member of the LPP program.
And you don't have to be a previous client of TuckerAllen to kind of be part of the program, right? You can just call, hey, I'd like to do it. How much is it? And they can just go to the website and find out more information, right?
Yes. Yep. It's all on our website, and you certainly do not have to be a past TuckerAllen client to be in that program.
And we've talked about the advantages of the phone calls, doing a transfer of funding into your trust. There's all kinds of benefits to it. And every time we talk and we think about changes or things that, the one thing that you want to not do is let your trust sit on the shelf and gather dust and cobwebs and not be thinking about it and what changes need to be made. And now all of a sudden it's piqued everyone's ears when you have a new administration that says, oh, by the way, we're not just going to tweak the death tax and the gift tax, we're going to, eviscerate it. And I mean, these are substantial changes. So I got to believe that that's something that someone would want to look at, become part of the program, and join. I think that's key. So also then remind you, tune in. We'll continue to talk through things just like this as we go every Friday at 1:00 Central Time. And then we'll kind of answer your questions then. So we're getting questions now in the Q&A section. We encourage you, if you have a question, submit it. We'll be getting to those very, very shortly as we continue to walk through the changes and implications as it relates to the Biden administration potential changes. So Missy, real quickly, before we move on to the next topic in this area, I mean, I guess when people are listening, they're thinking, I mean, is this something I need to be concerned about now? Should I be taking action, just thinking about it? Is it good to just come in and just do a health check, I'll call it, on what I have?
Correct. I'd always recommend coming in and talking to an attorney to make certain that you're up to date. And especially when we got future changes like this that might be happening, it would be critical to come in and talk with your attorney about how to address those changes. Now, nothing has been set in stone yet, but I would encourage everyone to reach out and at least meet with an attorney and talk about what to do if these changes go forward. So that way we can have a plan in place. You don't want to wait until the gift tax tanks before you start making gifts. It would be great if you did it now.
Yeah. And actually, if you're watching and you're thinking, well, I haven't implemented gifting as part of my estate plan, it may be something that could benefit from you, right? And you may want to implement it now and start making those, those plans, I would imagine, right, Missy?
Correct. We can't really plan on when you're going to pass away, but we can certainly plan on when you're going to make a charitable gift or a gift to your friends and family.
Yeah, absolutely. Plan for tomorrow, on today. So, all right, Teresa, now you're up. You've been listening to us go back and forth about some of the proposed changes. It's your turn. I kind of alluded to it early on, that stepped up basis. That's something if you're familiar with it, you know it, but many people don't know what it is. So let's start there. What is step up basis?
Yeah, so a step up and basis, I feel like these are just like really technical terms. So we'll break it down into step up and into basis. Generally, what we're talking about is essentially a recalibrating of an asset's value throughout time. So when you first purchase an asset, for example, if you first buy your house, the basis is the value at which you purchased it at. And then throughout time, an asset such as a house would appreciate. And then so when somebody passes away and they pass this house to another person, that house or that asset has grown to another value. And then so when the new owner of the house wants to sell it, then they get to then there's a gain on the asset in terms of the value, right? And so there's a step up in the basis, because essentially what the basis, the recalibrating is saying, hey, we're going to readjust. And then so when the new owner sells this house, we'll say that the basis was just the newest, most recent valuation of it. And in that way, it's a mechanism to minimize or to reduce the capital gains tax, right? Because the tax is on the gains that the property appreciated. So you want to minimize that by kind of upping the basis.
Yeah.
So that's kind of, I hope I explained that okay.
Yeah,
But that's essentially what a step up in basis is.
And it's hugely important, not only as the planner, but the recipient perhaps, so that you understand kind of, I had this conversation with someone and I didn't know a lot about it, right? And so I think it's important to understand it. So now let's turn to what is the current practice of step up and what is the proposed, what we're hearing. There's no official proposal, obviously, that the rumor mill about what the Biden administration is going to do with it. Kind of what are you hearing as well?
Yeah, so really it's an on and off switch. It's not like what Missy and Kevin are talking about like fungible numbers. It's really right now, the case is step up in basis is allowed. So when an asset is being passed to a beneficiary, upon a person's passing, the step up in basis applies to the assets that they receive, the beneficiary receives. And then the talk about the change for this is that they might eliminate the step up in basis so that once a beneficiary receives that asset, when the beneficiary wants to sell that asset, then they have to pay the tax on the gains.
So let me ask this, Teresa, and you may not know, is this a cumulative? I mean, we're talking about tax on tax on tax, and it seems like, okay, now they're going to pay gains taxes on, because let's just assume there's no step up. Then they may exceed the gift tax or the death tax. Are these cumulative taxes, right? On top of what they're getting?
I mean, I think if you're in that population where it's like, yes, you're really wealthy, and right now you are going to be above like the 5 or the 10 million, like 5 million per individual, 10 million for couples, then it could feel cumulative because all of these different changes would apply to you. I would say in terms of the step up in basis change, that might affect a larger pool of the population, just because let's say you're a person that has held on to your home for 50 years, right? Then the property probably appreciated quite a bit in those 5 decades. So
Teresa,
Missy,
can you give us an example using that with like just round numbers about selling a house that
sure, yeah.
held on for 50
so
years?
Let's see. I don't know how much a house cost 50 years ago, but let's just say you bought a house for $100,000 back in 1960, and then you hold on to this property, you continue living in it, and then while you're alive, you're saying, oh, you know what? I'm doing my estate plan. I'm going to pass my home down to my daughter, and then so. Let's say I pass away in 2010, so 50 years later, and the home at this point has grown to $500,000 from 100,000 to 500,000. So when my daughter gets this property, she's inheriting a $500,000 property, right? And then the step up in basis, the benefit of that is if she wants to sell it, she doesn't have to pay tax on the $400 gain. $400,000 gain, because that's what the capital gains tax would apply to that difference. The step up in basis allows her to say, okay, I'm just going to adjust the basis from 100 to 500 so that I can just sell the property without worrying about capital gains tax. If we eliminate the capital gains tax, then she can still sell the property, but when she sells the $500,000 property, she also has to pay the capital gains tax on the appreciation throughout the 50 years. So.
And I assume it applies, stocks, right? I think about someone who had a stock, back in the 30s, and they just decided to hold on to it, and then they give it to their heirs. And that stepped up basis may go away, and now instead of the value then, they get the value when it was purchased.
Yeah, exactly. So like even with stocks, like that could appreciate even like faster. Like the real estate example is like the more kind of safe bet. But if you got really lucky with like inheriting stocks, then that could potentially mean a huge amount that's going towards the gains tax when you inherit.
Yeah, it's a huge one. I mean, that one, it's interesting. That's why when I started out our conversation today was most people think, well, the death tax doesn't, this isn't going to apply to me. I don't have, $23 million or whatever it may be, but the changes are from top to bottom. I mean, it's going to affect every single person potentially that dies and transfers property that doesn't properly plan. So that again begs the question, what are the implications now? Let's just say, okay, we maybe be leaning towards the elimination of the stepped up basis. What should be people thinking to do? What's that going to do with their estate planning process? If you have a client that comes in now, what is it kind of the suggestion of what they should be thinking about?
I mean, this one's a little kind of difficult to plan around because Missy or Kevin, if you guys have any clever ideas about how to like work around if the step up in basis is eliminated, just because in terms of the beneficiary, I guess the good news is when the beneficiary receives the property, if you're saying, hey, I want to give it to my daughter so she can hold on to it, maybe she can keep it and use it as a rental property for like as an extra income source, then at least she's not selling it. The capital gains tax applies when the beneficiary is selling the house.
Mm-hmm.
So there's like silver linings there in that at least the capital gains tax doesn't apply just by the act of the transfer itself.
Right. You mentioned capital gains because that's another thing that's been talked about is raising the capital gains tax, right? Or making it, at historic lows. So now and when I say tax upon tax upon tax upon tax, I think that's where we're going is we're talking about increase of income taxes. We're talking about an increase of the death tax, the increase of, or the gift tax, basically, eliminating the stepped up basis, increasing the capital gains. So I think as people are watching, there has to be, a big conversation with that. In fact, somebody just asked, it's funny, I was just thinking the same thing. Is the current capital gains tax 15%? Aren't they planning to raise the capital rate? They are. That's what I've heard. And certainly that's why I think to have proper planning, to really bring in your financial advisor if you have one, bring in an accountant if you have one. Let's sit down with your estate planning attorney and let's really devise a way. Let's just kind of, as things start changing, what is the best way to handle it? Maybe it's, moving things here and there, putting them in different areas, separate trusts, whatever it is. I know Missy mentioned, irrevocable trusts and ILITs, and that's the point of a plan. I think that I've always dispelled the notion that's easy to go online in these locations, these websites that say, do your will now, do your trust now. But the point is there's real no thought behind it. And it'd be like me saying, let's do virtual surgery on yourself right now. And, they can walk me through how to do it, perhaps, but it's certainly not the best way to do it. And so, it is, and answer that question, yeah, no doubt. I think there's going to be radical changes coming about that may toss upside down some of the planning that's been done. And it's going to just be worth a conversation, a consultation with an attorney that practices exclusively in areas that you three do. So any other thoughts about what planning should be done as we think through those things before we get to some of the questions?
Sure. So I'll go a little bit more into irrevocable trusts here because I know I threw out the idea of an irrevocable life insurance trust, but for most people that doesn't make any sense at all to them about what that is and generally what irrevocable trusts are. So an irrevocable trust is when, okay, let me back up and say an irrevocable trust sounds very scary. It sounds like you can't revoke it, but it can be revoked if changes happen in the future. It's just a little bit more complicated to do it than a normal revocable trust. An irrevocable trust, it can be set up so that way assets that you put into this trust are not considered part of your gross estate and therefore aren't subject to those taxes. You would put those assets into that irrevocable trust, and then you're not supposed to access that trust other than perhaps getting income from it. And those assets will sit there until you pass away and then get distributed where you want them to be distributed to. So it's just like a normal trust. It's just that you can't really get access to those funds anymore. So we wouldn't put something like your bank account into an irrevocable trust because you need that for everyday living. But we could put your house into an irrevocable trust because you're not buying and selling your house every day. And if you did sell your house, you just buy a new house in that irrevocable trust. So the easiest thing to put into an irrevocable trust to shelter your assets and reduce your estate tax threshold is a life insurance policy, because that's not something you're using every day. You pass away and then there's money in there. So it's a really easy asset to put into an irrevocable trust. You don't really have to worry about it too much. You just set it in there. And then when you pass away, it might be $1 million policy. That $1 million will be passed on to your kids or whoever your beneficiaries are. And then that $1 million isn't considered part of your estate tax over here, so there's no taxes on it.
Good. Anything else from anyone else before we get to the live questions that are submitted? All right, it's time to get to those. And if you have questions as we're going along, go ahead and submit those in the Q&A section. They're coming in now, and I'll be reading some of them off, and let's see if we can get some answers to everyone. All right, Missy, coming right back to you. This was submitted. My house is paid for. It's designated TOD to my two grown sons on my death, registered with the county records and in my will. Is that enough, or do they need a trust? I know it's complicated because we'd have to ask more questions about what they have, but go ahead.
Okay, so just to start out with it, everything goes to plan and you pass away before your kids. And you've got it all set up with that beneficiary deed recorded in the recorder of deeds office that says upon your death, the house is going to automatically go to your two kids. Then yeah, it's going to pass to your kids, and that's great. The downside is that life doesn't always go as planned. So that's why we like to have a trust in place. So if one of your kids passes away, that means the other kid's going to end up with 100% of the house. And if that child that passed away has kids of their own, which would be your grandkids, usually you would want your grandkids to inherit their parents' share. So it would be 50% to your adult son's kids that passed away, and then 50% to the living son. That would not happen with that setup. Then if both of your kids should pass away, it's going to end up in probate because there's no living beneficiary to take under that beneficiary deed. And then we also have the problem if one of your beneficiaries becomes incapacitated and is on Medicaid or other forms of government assistance, the government will actually take that inheritance and steal it and reimburse themselves for the care that they've been providing. So that the government would own 1/2 ownership in your house then, which is not an ideal situation. With a trust, we can have a special needs trust set up inside of it, so that way if your children do become incapacitated, that money and that house will still be there for them, and they could use it, or they could sell it and use that money for their benefit and not have the government come in and take that money to reimburse itself for their care.
Yeah, I mean, it's like I always thought about for many individuals, and again, to dispel the notion that trusts are for people that have things, a lot of things. I look at it as like another blanket, on top of a blanket, just in case the first blanket doesn't work. You get a trust as kind of a backup protection plan in the event you maybe acquire more property. We talked about pour over that. I think Teresa's the one that says from basket to basket or bucket to bucket. You've gone to the step for a will, go one more further for the trust, right? And then just kind of make sure you protect yourself all the way around. Yep. All right. Kevin, you mentioned SLAT, the acronym. Mm-hmm. So if I'm unmarried or I get a divorce, can I utilize a SLAT?
Yes, so absolutely. So within SLATs, there are provisions where you can create like a floating spouse provision. So where you don't name a specific person, but you do have this, you have a individual, at least in the trust, that's floating, and that there's no name to them. It's just said my spouse. And so then that way, if you did get a divorce and you had listed your ex-spouse in this trust, now the document still works if you get remarried, because we have this floating spousal provision.
If you want more information, since it seems really complicated, give us a call, set up an appointment. Teresa, how exactly are types of irrevocable trusts able to decrease the value of the estate? And I know that Missy was
Missy touched on this, I think, multiple times, but I guess I'll kind of put my little spin on it, because the way I like to think of irrevocable trusts is they're like a completely separate entity from yourself, which is why it helps decrease your estate value, because essentially whatever you're putting into that irrevocable trust, you're saying, hey, that's not mine anymore. So then when you pass away, that's not, the assets inside the irrevocable trust are kind of subtracted from your estate.
So what are the differences? I'm going to come say with you, what are really the differences between revocable and irrevocable when it comes to your estate and when you're thinking about planning? What are those key differences?
Yeah, so think about the revocable primary purpose to avoid probate. Because everything that's still in the revocable trust, you're the trustee of that trust. You can still manage all the assets in that trust. You retain control. The main benefit is that basket where when you put things in there, it's not going through probate. So ideally, that's why I think with the property question we just answered, we recommend a trust, even if they have a will, just because a trust is a little more malleable with changes in life down the road, especially with beneficiaries set up. So think of a revocable as a basket, and you're saying, okay, I still want to keep everything. I want to be able to play with all my assets in this basket still while I'm alive. My goal is just to avoid probate. The irrevocable trust is the lockbox, where you're saying, okay, I don't plan on touching these assets. I'm putting it in here because I plan on preserving these assets for my beneficiaries, for my kids. And then so I'm saying I'm giving this up. Because I'm giving it up, it's in this lockbox. My creditors, divorce proceedings, any lawsuits or anything, that cannot touch things that are inside your irrevocable trust. Likewise, after you pass away, things inside that lockbox are not going to be counted as yours.
Great. All right, Kevin, what happens if my estate is over the estate tax threshold at the time of my death?
Sure. So what happens in that case then is that there will be a tax that is paid on every dollar that is above that estate tax threshold. Whether the estate tax, whether it gets lower to that 3 million number, and you have 3.5 million, then we would have $500,000 there that would get taxed at that 40% rate as it is right now. Or if it is changed in the future to a higher tax rate, it would be taxed at that level.
Missy, a pretty broad question. So let's see if we can tackle this one. Are there major changes that I should expect in probate law in the next 5 years?
Okay, so probate first, let me explain, is controlled by each state. So most of us here operate in Missouri or Illinois, and they have very similar rules, and they're controlled by our state governments. So what we can expect coming from our state governments is always a bit more in question. But it's been pretty solid in probate law for quite a while. If you want to talk about taxes that are controlled by like the government in Washington, those change quite a bit and quite a bit often. Like we had the Secure Act come out in 2020 recently, and that really turned retirement planning on its head for inherited IRAs. And that does happen quite a bit. But generally speaking, probate laws that are controlled by the state, those don't change very much.
Got it. So question came in. I'm going to go ahead and stay with you, Missy. My understanding is that proceeds from a life insurance policy are not taxable. Therefore, they wouldn't count against the estate tax limit. I assume that he's saying if they're out of an ILIT, right?
Okay, so I'll clarify this. So there are a couple of different taxes in play. Proceeds from a life insurance policy are not taxable as income tax. It's not considered income if you inherit $300,000 from grandma. However, it will be counted as part of the estate tax for the total estate of grandma. So if grandma is passing down over $11.7 million in 2021 when she passes away, then that would be taxed at the estate tax threshold rate. Grandma's estate would pay that tax and then pass that money on to whoever is inheriting. So you just got to remember that there are a couple of different taxes.
Right.
Income for most people, not taxed. When it comes to life insurance, but there still would have to worry about estate taxes.
Yeah, and I think that's the whole point is the big dispute that you hear when you talk about the death tax is, the Biden administration wants to capture as much money as they can under that threshold. So of course they're going to account life insurance. It's not, set out in an ILIT or something like that. So similar question that came in, I'm going to stay with you, Missy, since it's dealing with life insurance policies. Why does an irrevocable trust need to be in a life insurance policy? Because you may have answered it. And if it needs to be, should I choose a life insurance policy that has living benefits like withdrawals for long-term care?
Okay, so an irrevocable trust can contain any sort of asset of yours. Life insurance policies tend to be the most popular asset to put into them because there's not actual money involved right now usually. Maybe there's like a cash value on it, but generally speaking, the value of the life insurance policy is after you've passed away. So putting it into an irrevocable trust is no hardship on you to lose full control over it and put it in that lockbox Teresa was talking about. Could you read that second part of the question, though? That part was a little confusing.
And if I choose a life insurance policy that has should I choose a life insurance policy that has living benefits like withdrawals for long-term care?
So something like that may not actually be eligible to go into an irrevocable trust if you have that much control over it. So the government wants to know that it is not really yours anymore. So if you have that much control, they may consider it still to be part of your estate, even if you tried to put it into an irrevocable trust, because you have all of those rights and control over it still. So it would have to be something you talk about with your attorney, and you'd have to bring in the policy, and we'd read it and we'd be able to tell you, yeah, the government's going to count it, or no, the government's not. So I wish I could give you a more firm answer, but I'm going to have to actually read it for that situation.
Well, good question, good answer. All right, Kevin, who pays the estate tax if my estate is over the threshold at the time of my death?
Sure. So that's always going, or almost always going to be the estate. So the person who passed away, their estate, they'll be the ones that will pay the estate tax on those that inheritance.
Yeah, and you've always heard that, the example of farms being passed down that have these substantial value and then get nailed with a death tax, where they don't have the liquidity to pay this tax without selling off the very land that they inherited, right?
Yeah, so that would be like the common situation that you would hear about. And in a situation like that, maybe something that hopefully the attorney that wrote this estate plan did, they may have put into the trust to say, we want to sell off these other assets to be able to pay for the estate tax for this family farm. So maybe, I'm not sure, but there could be, the people, they may have other assets. Maybe there was a brokerage account or something like that, and they would like to take the assets from that brokerage account to be able to pay for the tax on this farm.
All right. And the last question that was submitted, if you want to have an answer or a question right now you want to answer, go ahead and do that in the Q&A section right now, and we'll get to it. Otherwise, we have one last question. I'm going to go to Teresa, and that is, if the step up in basis is eliminated, does that mean my beneficiary will have to pay a large tax because of the property appreciation and when they receive the home, which that was really what we talked about with Missy, right? So they'll have to pay the tax perhaps when they sell it, or when they receive it.
Yeah, exactly. So when they receive it, you don't actually have to worry about it yet. But you really, if the step up basis is eliminated, then you're worried about the tax if the beneficiary sells it.
All right. Well, that's all the questions, I think. Oh, here's one more. And we'll see, Teresa, might as well stay with you. Are there any products you can put in an irrevocable trust that you can use during your lifetime? Maybe we just open up to any of you. Anything you can put in.
So a house is actually a really good one, because with irrevocable trusts, if you got it paid off and you just what you want is for your house just to pass down to your kids, you can put it into the irrevocable trust. And there's provisions, I know, in our irrevocable trust saying any real estate that's in here, the grantors, the people who created this trust, get first choice, first priority to continue enjoy and residing in the home. So you can still use it.
Yeah. All right. So if there are no more questions, that's all the time we have for today. I encourage you to tune in on Friday, 1:00 Central, TuckerAllen Live on Facebook. We're going to be talking with Teresa about adult guardianships, when and why. So you want to tune in 15 short minutes, fill you in on adult guardianships and whether that's and why that's important and when it's important, what you need to do. And you can ask questions also during that 15-minute segment on Facebook. You want to go ahead and go to our page at TuckerAllen and go ahead and look for that information as well. And you can follow us. Go to TuckerAllen.com. You can schedule a consultation right there in any of our offices, and you can give us a call at 866-335-3375 to schedule a consult and talk about the things today that we discussed with regards to the impending changes, and just do a checkup, kind of a health checkup on your trust and estate planning to make sure it's where it needs to be. And we can give you some advice as to what you should be doing with these impending changes from this administration. And also you get more information about that legacy protection program, something I think is really critical. We talk about it every week when we're on Facebook, and we talk about it here as well, just because of the value that's given. So check it out on the website as well, the legacy protection program. You don't have to be a previous client. You can sign up for it and get the benefits for this year and moving forward as well. So continue to tune in. Tune in next month for our virtual town hall. You get more information by going to TuckerAllen.com. Follow us on social as well. You'll get updates with regards to our TuckerAllen live segments on Fridays. Check us out. It's only 15 minutes. You can do it from wherever you are, in your car, comfort your home, at work, and ask questions. We'll get you answers. So until Friday, we'll see you at 1:00 Central on Facebook, and then I'll see you again next month at the virtual town hall. Have a great rest of the week.